Okay, the next case we'll take up will be Michael SIBONI versus William Allen and James Sonnier et al.
If it please the court, your honors, my name is Russ Lapierre from the law firm of Lant, Weechens, Lapierre and Ayers in Ocala. And before I begin, I just want to say that over the years I've had the privilege of arguing in a number of courts, but this is the first time I've had this experience, and so...
So you're not going to ask for rebuttal time, huh?
Yeah, I don't need to do that, that's right. One thing I did, not so much of a prop, but just to kind of save even some words, I just brought a copy of the indemnity provision. But I highlighted in blue, I think, are the operative clauses of the provision. The issues are pretty straightforward. This was a case that was brought by beneficiaries of a land trust that they had created themselves, and they sued a number of people.
It seems to me really that the facts aren't really all that critical to the issues that are before us. And so if we can try to perhaps narrow the issues, would you agree that excusable neglect was not argued, that there was no motion and no argument made in terms of excusable neglect at the trial court level?
I would not say it that strongly, but you have obviously focused in on the third of our arguments, the weakest of the arguments. But I would not say that there's nothing in the record that was...
Well, the trial judge made a finding in his order that...
He made several findings. That's why we're here. There is, well, I'll call your attention to the affidavit of the appellant, Mr. SIBONI. My own affidavit alludes to the fact that there were these negotiations going on between Mr. SIBONI directly and appellee's counsel, and it was only after, in fact, it was 6 days after.
All right, I understand. All right, so you're suggesting that his finding that excusable neglect was not pled, that's error.
What I'm suggesting is that his order seems to say that there was no indication of excusable neglect, and that's just not the case.
Let me find his...
For two reasons.
Well, he didn't find excusable neglect.
No, he did not.
And is there any evidence in the... What do you have to contradict that? I mean,
the affidavits that were before the court at the hearing and in the record of Mr. SIBONI, that he had been engaged in discussions about the indemnification provision and about securing it from them up until the point that they sent the September 2 letter saying we refuse to comply with the indemnification provision. He got that on the 8th, and 6 days later we filed our motion to enforce the previous order. So
you agree you could file the motion for attorney's fees and not set the hearing and continue on with negotiations, right? I mean, you could have done that. You could have filed your request for attorney's fees, not set the hearing, continued on with negotiations,
yes,
and then you'd be within the 30 days.
Yes, sir, absolutely. If in fact the 30 days applied, that's what we should have done.
Right. And before we get to that argument, which is an interesting one, let me ask you, given the unique facts of this case, how it's come to us, is there any reason you couldn't sue for breach of contract if the trial judge's decision was affirmed?
Oh, an independent action for breach of indemnification?
To recover the attorney's fees?
No, there's not.
Okay.
No, there are complicating factors, but that doesn't change the...
So you can win either by us reversing the trial judge, or if we were to affirm, you could bring the independent action.
Right.
Okay.
Right. Yes, sir.
Right. Now, the trial court says in his order, the defendant has not filed a motion or otherwise argued that there is excusable neglect in failing to file this motion within 30, I guess it should be 30 days of the dismissal. So you take issue with that. Certainly didn't file a motion. Absolutely did not file a motion. And at the evidentiary hearing on the 23rd of October of last year, we didn't go on about excusable neglect. There wasn't mentioned that... Okay. All right, so let's talk about the interplay of the rules, which is really the
Okay, you want to just go to the second issue, which is Rule 1.
Whether Rule 1525 applies in relative to 1250B.
Okay. Let me just say this. If you answer the first issue the way I believe it should be answered, you don't have to address this issue that you reserved in Carter against Lake County. But since you've asked me to address it, I'll do it. As you know, in Carter against Lake County, it was really the appellee who invited the court to construe 1.250 as somehow being included under the conditions of the attorney's fees rule 1.525, and this court properly didn't do that and reserved it, was unnecessary. I would suggest also that to do that is really to ask the court to do something that is unseemly jurisprudence. I think what lower courts who didn't fashion the rule should do, if they disagree or if they think that the rule ought to include dropping parties, is say so, but rule on the language that exists. Because it's very easy for the Supreme Court to amend 1.525 and add including dropping of parties. That's not in there right now. And if the notion, which apparently Lake County wanted to do in the Carter case, is, well, because the mechanism procedurally is the same. You give a notice, you're dropping a party.
If you had a lawsuit and you get a judgment against one party, and there's another party or perhaps more than one party that on which the case is still pending, does 1525 apply?
No.
Okay. So would it be your position that if in this case, for instance, the case proceeded as to the other defendants and it, went up on appeal, trial judge ruled, went up on appeal, went to the Supreme Court, came back, tried it again, 7 years later, the case is finally resolved against the other defendants. Does your client have those 7 years plus 30 days in which to seek their attorney's fees?
Ultimately, yes, and here's why. Because during that 7 years, the client who's dropped, or the party who's dropped, can always be added again. See, that's the difference between the finality that 1.525 contains, a judicial finality with judgments, a proponent's finality with dismissal.
Well, dismissal, you could dismiss a case without prejudice and refile it.
That is true, but even then, there are different conditions that apply to a dismissal of a case than a dropping of a party. If I dismiss without prejudice, I have a two-dismissal rule I've got to be mindful of. I may have costs and that I've got to pay.
Well, if you drop a party, do you effectively have a two-time dismissal rule?
No.
So you could add a party, drop them, add them, drop them, add them, drop them?
Well, the rules don't speak to that, do they? And the case law doesn't speak to it. I mean, 1.250 for dropping parties is really intended to deal with, as the court knows, different situations.
Well, is there a difference between, we call, the new rule is called, or not new rule, but the other rule is called dropping a party. But isn't it equivalent to voluntary dismissal as to one party?
No. I mean, that's the language that the treatises, both on the federal rules and the Florida rules, have long labored to make clear that dismissal is not an appropriate term for parties. Dismissal applies to a lawsuit, to an action, because then all the res judicata preclusion issues, everything that's involved with dismissal apply. But just dropping a party or dropping a claim is not the same thing.
You're familiar with the Bayview decision?
I'm sorry?
The Bayview decision?
Yes, sir.
And that provided that recovery of cost in a case where the plaintiff dismisses an action also applies to rules covering cases where the plaintiff dropped parties. So that's the connection between dropping a party and dismissal.
That certainly would be an argument for why you should treat 1.250 the same as 1.420 dismissal. My answer back to that is, well, there's still other considerations that distinguish dropping a party from dismissing a lawsuit. And, after all, who's the master of the language of the rule? The court that fashions it. Supreme Court hasn't done so.
Would you agree the rationale behind the attorney's fee rule is so that we don't have parties seeking attorney's fees years later? If we want to set a definite time frame when the case is over for them to seek their attorney's fees and not wait years later and say, oh, by the way, I was the prevailing party, I should get my attorney's fees.
When the case is over, I agree. That's the key language. But
and should it be any different when the case is over as to a particular defendant? Is there any basis for the rationale being different?
Well, yes. I mean, first of all, your question is a really good question. It's one that I suppose should be addressed to the Rules Committee or to the Supreme Court itself.
You're asking for a strict interpretation of the rules by the literal reading of the language of the rules, that you win under a literal reading.
I always do, because I think that's the proper rule for a court that either didn't create the statute or, in this case, didn't fashion the rule. But, in addition, I'll go back to my real quick mention before, and that is that, as the rules stand right now, a party can be added back again. Once you dismiss a case, you only get to add back or to refile a second time. The two-dismissal rule does apply. There isn't such a thing in the jurisprudence although you're right, Your Honor, the Bayview case does at least provide for the bar of paying costs before adding a party back.
Well, and the rule 1.250B specifically provides that parties may be dropped by an adverse party in the manner provided for voluntary dismissal in Rule 1.20. So that's the connection.
It's the connection, but it's not the connection that Lake County urged this court to really create in that case. Just because you use the same notice procedure doesn't mean that everything that is involved in dismissal of an entire action applies to dropping of a party. So, if the court is inclined today to answer, in this case, the question that it reserved in Carter against Lake County, my argument and my urging to the court would be to answer it, no. The rule is straightforward. The conditions are two. They're both matters of finality, and if any other condition is to be added, then that policy, which your question went to, Your Honor, is one to be fashioned and decided by the Supreme Court. May I just conclude real quickly by saying that I still think you don't have to reach that issue, because the first issue is so straightforward. How can you grant a motion to abate and abate an action until the opposing party meets the indemnification provisions in the...
Well, we would have to draw an inference that the granting of the motion to abate was done for this reason, correct? It's an inference that would need to be drawn.
I don't think so. There's just no other way to explain that ruling.
Well, the trial judge offered another way.
No, he offered his intent, but jurisprudentially, intent is never determinative in the review and evaluation of an order.
But the language the judge used creates more than one inference as far as why the motion to abate was granted. And if there is more than one permissible inference, then I don't see how you prevail on that argument.
You're absolutely right, if there is. And my argument, there isn't. There's no, to say otherwise is to fall prey to what people sometimes criticize the law as having very labyrinthine reasoning. The motion to abate was premised on one thing only: honor the indemnification provision. The order, the motion itself requested that. The order granted that, And the alternative, if it wasn't met, was to dismiss. If the case had been dismissed for failure to honor the indemnification provision within the 90 days, then we would be squarely where we've been talking about. 1.520 and its time limits would clearly apply, and we would have acted.
Could the trial judge have properly addressed your motion by saying, motion to abate is granted, however, the granting of this motion should not be deemed a final determination on whether indemnification is required here?
He could enter such an order. I think that it would be a nonsense order under these conditions.
I'm sorry, it would be
a nonsense order. If, in fact, he was not certain that this very clear, I mean, this is not, it's a comprehensive, but it's a clear, it's a straightforward.
Parties, it's not uncommon for parties to present an order to a trial judge saying, we're trying to work this out, and we'd like you to abate the case. And the trial judge typically will sign off on
Absolutely.
that. And it seems to me that in some ways that's really what the trial judge was doing here. There's an issue in terms of the indemnification. We're trying to work it out, and we'd like the case abated for a certain amount of time. And so the trial judge says, okay.
Show me the record where you find that. The only thing in the record is the motion to abate, and it's straightforward.
I've got his order.
Then his order, to the extent that he belatedly expresses his intent, is irrelevant. What the court always reviews is the operative effect. What does the order do, regardless of intent, or whether no intent's ever stated? What does it do, and is it justified or warranted in what it does?
Well, but the trial judge could have said, however, I'm not addressing the merits of the motion, like I just indicated. Or the trial judge had said, I find indemnification is required here. I abate the action for 90 days for the plaintiffs to comply. Here, the trial judge didn't go either of those ways.
That's right. That's right. And I think the latter would have been the thing to do, but that doesn't change the ineluctable consequences given what the premise. Condition proceeding with this action is to provide the indemnification required by paragraph 11. He agreed.
Does it matter that there was an order denying the motion for rehearing where the court itself commented on its own intent?
No, it doesn't. That's the reason I discussed what I did about intent. I mean, you get probably the majority of orders before the court. A judge doesn't express his intent. I mean, that it's interesting. It may be historically even amusing, but it's irrelevant. It's what the order does, and what it is, what it does. Warranted.
Well, this is an interlocutory order. The judge could change it at any time, right? I mean, the judge could have granted your motion to abate, said indemnification is required, and then 10 days later say, I've been thinking about it, and indemnification is not proper here. So isn't his language clarifying his intent? Why isn't that just a correcting, if you would, or clarifying interlocutory order, which he could have reversed anyway?
But not by the time that he's denied the motion to enforce, because at that point we've got a final order, not an interlocutory order. So the motion to rehearing was not from the May 22 order abating. It was from the denial of the indemnification that necessarily had.
But when he denied the motion to enforce, the day before he denied it, he could have changed his ruling on the motion to abate, right?
Yes, sir. He could have.
Okay.
Yes, sir. Mm-hmm. Okay. Thank you.
All right, well, thank you. I know it was a unique experience for you, but we appreciate your argument.
Thank you.